Good morning, everybody. Welcome to our live stream today. It's a special one. Normally, we don't do it on a Friday, but we want to get you the information that you need. Here for LA County, they passed a resolution, and so we have one of the most qualified people that you could imagine to speak on the topic for us. And anyway, this is AOA. We're here for you, and we're one of the largest individually organized groups of apartment owners here in the state of California. And this has just been a real crazy time for all of us, for sure. And anyway, so what we are trying to do is give you ideas that'll help you make or keep more money than ever before. And we're committed to helping you become as successful as possible in every way possible. And one thing I did want to mention, we have upgraded the forms and the forms packets, like the move-in packet. If you are on an Apple, you're saying, woohoo, this is awesome. If you are using Windows 10, you may be asking the question, or you will ask yourself the question, how do I get this thing open? And if you do a right click, you download it to your desktop. If you do a right click, then open with Adobe. That's how you'll be able to get it open. The kind of like when they switched the coffee on you and you didn't know. Well, this is what's happened here. Microsoft with Windows 10, they make these PDF files open with Edge, their web browser, and who knows that, right? You just kind of open it up, you don't think about it. Anyway, that's what the deal is, and so just wanted to mention that so to help you avoid some frustration. I also want to mention we have closed caption on Facebook, so if you'd like that, closed captions, go to the AOA Facebook page, and you can catch that. And man, if you guys missed it, last week was amazing. We had an ex-gangbanger who was leading a gang, and he's called the shot caller. He spent 12 years in prison, and then he spent 10 years in property management, and he brought a great talk to us last week about how you can protect your property. So you want to catch that for sure. And then we had Mr. ADU speak yesterday, and anyway, next week we have a 1031 exchange seminar by K Properties, so you want to catch that as well. So definitely subscribe to the newsletter if you haven't. If you're an AOA member and you're not getting that, that means that you need to update your email address with us, and then it will happen. And I want you, please, we're going to have so many questions that you have to hold the questions to the end, because you may get your question answered before we get there. So just please wait. And anyway, finally we get into it. Our speaker today, he has been in the business of evictions for 45 years. He has 20 attorneys on his staff. He's a landlord himself. He's the AOA $1 Million Trade Show favorite for sure. And he also writes for the AOA magazine every month for LA County, the legal Q&A. You definitely want to check that out every month just to stay informed. So it's my pleasure to introduce to you today the founder and president of the law offices of Dennis Block and Associates, Dennis Block.
Thank you, Jeff. Always a pleasure to come to the association and do these webinars. We have so much to talk about today. And as usual, we have a governmental assault on income property owners that has now been extended by the County of Los Angeles. These rules are incredibly confusing. I think they were designed that way, but the truth of the matter is it always comes down to this equation, which is that they are robber barons, where they are taking from the rich and giving to the poor, taking away our property rights and just handing them over to other people. That's where we are now, and this is going to continue on and on and on. And truly, it's an assault against all property rights. But my job here today is to go over the specifics of the new LA County rent control ordinance. But I really can't do that without going over the state law dealing with the eviction moratorium. And then for our members here in Los Angeles, to going over the city of Los Angeles and what their requirements are, and finally moving over to the new county ordinance. We have to be cognitive of the fact that you can't just comply with, quote, the state law. If, in fact, the city of Los Angeles has an ordinance, which they do, dealing with eviction protection, then you're going to have to comply with that. And notwithstanding the fact that the LA County, Los Angeles County, has a new ordinance, as I will explain, people with property in the city of Los Angeles can ignore the county ordinance because you really have to comply with the stricter LA city requirements. So again, very confusing, probably designed to do so that landlords have to tiptoe through the minefield to achieve whatever property rights they are attempting to gain. So let's go over the state first. I'm going to move over to the city of Los Angeles, and then finally we'll hit the new county ordinance. Under the state law, if a tenant owes you rent, for example, you have to serve the new 3-day notice to pay rent or quit. That's a 2-page form. Of course, you can get that, as you can get all the forms on the Apartment Owners Association website. When you serve that notice, you need to immediately apply, if you haven't done so already, for relief under the California Rent Relief Program. That is a website that you can go to called housingiskey.com. Housing is, I-S-K-E-Y, K-E-Y.com. Once you've applied for that and you've served your 3-day notice, you need to wait at least 20 days from when you applied for that rent relief. Once that has come and gone, those 20 days, then you have the right to file an unlawful detainer action, an eviction lawsuit. Again, we're just limiting this right now to what the state requires. So, for example, if you're a city in Orange County, you're out of LA County, clearly you would serve the new 3-day notice form, and then if in fact you've waited 20 days to comply for the Rent Relief Act, you've applied for that, then you're allowed to bring forth an eviction. Now, a little known exception is that if your tenant has applied first for the California Rent Relief Program and has communicated that to you, then technically you cannot proceed forward with an unlawful detainer action. So if they've applied first and they've communicated that to you, there's no reason to even serve a 3-day notice at that point in time. Now, if you get a rejection from the California Rent Relief, then of course you can proceed with your 3-day notice and an eviction. Every time a tenant in the state of California owes you rent, and I don't really care the reason why, you need to apply to the housingiskey.com. Every single case, if a tenant owes you rent, you need to do that. The issue then comes is once you've waited those 20 days after you've applied, and again, we're just talking the state, and you've filed your lawsuit, you've served your lawsuit, and the tenant hasn't answered the lawsuit. Now, if the tenant has answered the lawsuit, of course, we would request a trial and have a trial date. But if, in fact, the tenant hasn't contested, then the next thing you do in a lawsuit is you take a default, which would then turn into a judgment for possession. The problem is that based on the way the law is written, you can't take a default until you get a rejection from the California Rent Relief Program. And in very few cases, even though the tenant hasn't complied, hasn't done their application process, hasn't submitted the documents that the state wants, you cannot go forward and take a default because you don't have a rejection. And the reason why you don't have a rejection is because the California Rent Relief, in most cases, are not issuing a rejection. So we have a basic catch-22 in the law between what the law says and what the rent relief program is actually doing. So in very few cases, we've actually gotten a rent rejection or a rent relief rejection, and then of course we can go forward and take a default in an unlawful detainer. But in most cases, the state is not issuing a rejection. In those cases, we've had some success if we can find any place where the tenant hasn't applied for the California Rent Relief Program at all. Usually we can get some sort of a notice from the state, or if no notice, then we'll do a declaration by our clients where we'll state that we have been told that the tenant has not complied, has not done their application, and therefore let us go forward with a default. We have had some success on that basis. So again, if you have a tenant who hasn't paid rent currently, immediately apply for the rent relief program, unless of course you've been told that your tenant has applied first. Serve your 3-day notice, and then we can go forward with an unlawful detainer. Now, the state eviction protection rules based on the pandemic is set to expire. Well, when is that? That is going to be March 31st, 2022. So that's coming up in about a month and a half right now. So at that point, for April's rent, you'd be able to serve a standard 3-day notice. You don't have to apply for rent relief for April's rent. That's April 2022, coming up in about a month and a half. In that situation, as long as you're not hamstrung by either the County of Los Angeles or another municipality like Los Angeles, then you can file your standard unlawful detainer action. So let's pretend you're in a city in Orange County. Then you can file your standard unlawful detainer action and proceed forward with an eviction. No requirement is necessary for you to apply for any rent relief for rent owed from April 2022 forward in time. Now, under the state requirements, you do understand that if you're not subject to any local jurisdiction, there are requirements and forms that need to be sent to the tenant dealing with statewide rent control. So be aware that if your property is not subject to any rent control whatsoever, so it's a single family home, for example, in the city of Los Angeles, you do need to inform your tenants that the property is exempt from statewide rent control, which is also called AB 1482. If you're leasing out property for a particular unit that is not under any rent control, again, a condo or a single family home, you need to have that contained in the rental agreement, okay? And of course, the AOA forms have that as one of their provisions in that. If you don't have that phrase in your rental agreement on new property that you're renting out, then your property is going to be, believe it or not, subject to statewide rent control. You have to have that phrase in your contract. For existing tenants, you need to send them a notice, not that they have to sign it, but send them a notice that the property is exempt from rent control. The same thing is true as if your property is subject to statewide rent control. That paragraph has to be contained in any new rental agreement that you enter into, or for existing tenants, you need to serve them a notice saying that your property is subject to statewide rent control AB 1482. So that's just as an aside, but please remember to do that. Now, under statewide rent control, even with this eviction protection right now, we can still proceed forward with evictions based on family member move-ins or owner move-ins, and also for renovation. Those are proper grounds right now today if your property, again, is not subject to any of the provisions of LA County or LA City. You can proceed forward to have a tenant evicted on the basis that you want to move in or a close family member, and it has to be either a grandparent, yourself or your spouse, your children or your grandchildren. Also, you can have a tenant evicted if you're planning on renovating the unit. Renovation is described as substantial renovation, where the work will take at least 30 days to complete and requires a building permit, like an electrical or a plumbing permit. So if you have property that is subject to statewide rent control, you can still ask the tenants to move for either of those two reasons. You can't ask them to move on the basis that you're wanting to sell the place. That would not be permitted. But you certainly can do it on the basis that you have a family member that wants to move in or you want to renovate the unit. So that's a very popular one, the renovation. You do have to pay relocation in those situations, and the relocation is equal to 1 month's rent, so not that big of a deal. Also, under the state law, you can right now today start an eviction based on a violation of the rental agreement. If the tenant has unauthorized tenants, pets, has alterations to the premises, any of these violations to the contract, or for example, a nuisance. These right now are grounds that you can go forward with to evict a tenant. So if they've got extra people, a dog, they put up a satellite dish on top of the roof, they're parking an inoperable car. Any of these reasons would be grounds to commence an eviction under the statewide rent control. Now, if your property is exempt from statewide rent control, again, let's pretend you have a single-family home and you're not in LA County, you're in Laguna Niguel, for example, then you can just serve a notice to quit. If the tenant has been there longer than 1 year, it's a 60-day, otherwise it would be a 30. So you can do that and just terminate the tenancy without cause because your property is not subject to any rent control, and you're certainly not subject to statewide rent control. But again, for your property not to be subject to statewide rent control, you have to have that either contained in the rental agreement or that you served notice to your tenant that the tenant is not subject, this tenancy is not subject to statewide rent control. Okay, that's where we are with regard to the statewide rent control. But remember, even though you might be complying with statewide rent control and statewide eviction moratorium, it's a whole different ballgame if your property is located, and we're going to start first with the city of Los Angeles. This is the most severe restrictions to property owners, I think, on the planet Earth. It is much more strict than even the County of LA requirements. And number one, I'm going to tell you that the city has now just extended their eviction moratorium. I think you'll be happy to know at first blush when I tell you that they've extended it to February 7th. Now that sounds pretty good since, what's today, the February 4th? But unfortunately, they've extended it to February 7, 2023. I kid you not. It's another year that we're under these severe eviction restrictions where tenants can literally basically ignore the terms of their contract and sit on your property, and the government expects you just to absorb these losses. What are those losses? Right now in the city of Los Angeles, and you can't make this up, a tenant can literally claim COVID and not pay rent from March of 2020 through January of 2023. Now, if you do the math, ladies and gentlemen, that's 35 months that the city has sanctioned, City of Los Angeles has sanctioned that a tenant who's claiming COVID doesn't have to pay the rent. 35 months. During that time period, of course, landlords have to comply with paying their property taxes. They have to pay for the water and sewage on their buildings and possibly other utilities. They have to pay their mortgage payment. And if your property is subject to LA rent control, you're going to have to pay your registration fees and your SCEP fees. And yet the city is expecting you to go without rent for 35 months. Now, yes, if your property is in the city of Los Angeles, of course, you can apply for California Rent Relief Program under housingiskey.com. But how many times have we seen where the tenants haven't done their part, haven't completed their application, haven't submitted the correct documents, and so your application is just pending, or they've done nothing? So what does that mean? Can you now evict because the tenant hasn't complied with the rent relief program? And the answer is no. You still can't, which means for 35 months, up until February 7th of 2023, basically a year from today, and I'll probably be standing here doing another webinar at that time, that you would have to go without rent for that unit, and no basis, ladies and gentlemen, of getting any rent relief from the state. Now, the tenant will ultimately owe that money, so you would think that the tenant would apply, because if the tenant applies and the money is paid by the state, then the tenant has no obligation to pay that. But we are finding lots of tenants just don't comply, and therefore the tenant will ultimately owe the money. But how does the landlord survive with 35 months without a rent payment? And hence the reason why there are at least 2 and probably more lawsuits against the city of Los Angeles, because obviously this is constitutionally a taking and obviously a violation of landlord rights. But that's where we stand now. We're just waiting for the lawsuits to run their course. But again, you're dealing with a situation of 35 months without receiving any rent payment. Now, when that big date comes, February 7, 2023, do the tenants have to pay the rent? And the answer is, of course they do. Now their time is up. But you see, the city in their ordinance states that their rent is still deferred for an additional year. That would be February 7th, 2024. February 7, 2024. Where are these tenants going to be? You think they'll still be in your building? They probably will move to Alaska or Hawaii or any other place, and you'll never be able to find them. So the city, without question, is merely stealing money from you. That's all it is. It's legislation designed to create a theft for landlords and their property rights. Of course, the statute goes on to state that they can only withhold if it's COVID related, but they don't have to submit any proof. And all they have to say is COVID, and then your case would be dismissed if we brought it forward. Now, under the city rules, which again are extended through February 7, 2023, there can be no fault evictions. This is insidious, which means you can't do an Ellis Act. So if you bought property, as I have some clients who have, with the intent to demolish, to build more units, which is supposed to be a good thing, all Ellis Act evictions are prohibited. If you bought a duplex to move a daughter in or to move in yourself, those properties are prohibited from doing an eviction because that would be considered a no-fault eviction. And again, this applies to property whether it's rent control or not. So if I have a house that I just purchased in the city of Los Angeles, which is not subject to any rent control whatsoever, and I bought it to move in, I can't move into my own property, at least until February 7th of 2023. I have tons of people who have bought property want to move in. The city of Los Angeles, in their insidious ordinance, is denying your right to move into your own house. But what about the people who just say, you know what, I've had enough. I want to sell my property. I want to sell my property. I want to move out of the state, which is probably a pretty good idea. If you have a tenant who's occupying a single-family residence, not under any rent control, and you want to sell your property, which obviously means you want to ask that tenant to move, again, you are prohibited under the City of LA ordinance from doing a no-fault eviction. So on that basis, you're merely going to have to wait to sell your property until February 7, 2023. What goes on in the minds of our elected officials, God only knows. Well, one thing is certain, I am sure that they do not own any income property. Because if they did, they would never do what they're doing. In the city of Los Angeles, you can do an eviction based on a violation of a rental agreement. But it can't be for unauthorized persons or unauthorized pets. So here you are. You have a rent-controlled unit or even a non-rent-controlled unit. And of course, you're subject to, in Los Angeles, you're not under RSO, Rent Stabilization Ordinance, you're not entitled to raise the rent. That's banned at this point in time until the moratorium is over, which once again is February 7, 2023. And it might even be extended beyond that. But in that situation, they bring in extra people into your apartment. Well, extra people means that your water bill is going to go up. If you're paying electricity, the wear and tear. Can you evict for that? I mean, the rental agreement says only 2 people. Now they've got 7 people. The answer is no. You can't. Based on the way the judges are interpreting the law, you can't evict for unauthorized persons. You can't evict for an unauthorized pet. They bring in a dog. It says no pets of any kind on the property. You can't do anything with that. So Los Angeles has prohibited those types of evictions. You can, and we do, evictions in the city of Los Angeles if there is alterations to the premises. Maybe they installed security cameras on the outside of the property, put up a satellite dish, I don't know, changed the carpeting or took it out, something to that effect. Also failure to maintain, and the tenant is hoarding or has filth and grime or throwing objects in and about the common areas of the property. Those are cases we can bring forth at this point in time. Also, if they're having an inoperable vehicle or they're parking violations, they're bringing in extra cars on the property in violation of the rental agreement. And then we come to a curious one, is that you can evict, I kid you not, this is the way they wrote this law. You can evict for a nuisance, tenant creating a nuisance, unless it's related to COVID. Now, I don't know how they got that one. So can you imagine even a scenario where a nuisance could be related to COVID? So we were kicking around that at the office. And of course, if it's related to COVID, then you can't. So we were kicking around the scenario of a person who's been very careful, has all of his vaccinations, doesn't want to get COVID, wears a double mask, right? And then he finds out that he got COVID. And he is so distraught that he takes a gun and shoots up the courtyard. Well, that's certainly COVID related. So I guess if you follow the moronic law as written by the city of Los Angeles, I guess you couldn't evict that tenant because it's related to COVID. But this is, ladies and gentlemen, what we're dealing here with politicians that are just trampling all of our property rights. So that's the rules with regard to the city of Los Angeles. Once again, if it's COVID related, which they're going to say it's COVID related, and do they have to show proof? The answer is, of course, no. You can't proceed to evict based on non-payment of rent. Your only remedy is to apply for the California Rent Relief under housingiskey.com. And if you don't get your money, or let's pretend that they do have a limitation of 18 months. Let's pretend they paid you 18 months. Well, what happens thereafter? We're talking 35 months by our wonderful politicians for the city of Los Angeles. Again, there can be no fault evictions. You just can't ask a tenant to move, even if it's not subject to any rent control. So if you want to move into your own unit, you want to sell your property, you want to do renovation, can't do it. Can't evict for unauthorized persons or pets, but you can evict for any kind of failure to maintain, inoperable vehicles, alterations, nuisance, unless it's COVID related, whatever that means. But now we move over to the County of Los Angeles and the new rules. The County of Los Angeles affects every city in the County of Los Angeles, every city, unless that city has a more strict eviction moratorium ordinance. And there are two. Believe it or not, the two are Beverly Hills and Los Angeles. So regardless of what I'm saying about the county now, and I have found some cracks, because that's what lawyers do, we try to find cracks in the law. If your property is located in the city of Los Angeles, forget about it. Whatever I'm telling you about the County of Los Angeles is irrelevant. And I know we'll get questions, and I know I will repeat that. So if your property's in the city of Los Angeles, you must only be concerned with the LA City Ordinance, which is the most strict, severe ordinance dealing with eviction protection because of the, quote, so-called pandemic. And by the way, while we're on that subject here, who's really affected monetarily by the pandemic? Who's lost their job? Right now, employers are desperate to find people to work for them. I'm looking for a receptionist, by the way. Send your resume into Dennis at evict123.com. We're looking for a receptionist. We're having trouble finding one. So I don't understand who's affected by COVID at this time financially that they can't pay their rent. Obviously, this is just a legislative boondoggle where anybody is just gaming the system, claiming that they're affected by COVID, when the truth of the matter is, I don't think anybody's affected by COVID at this point in time. Everybody can get a job at this point in time. But for the amount of people who aren't paying rent, this is just criminal. But as we all know, if you are in a situation where the government allows someone to do something, then someone's going to take advantage of that. Just like walking across the border. If they allow you to walk across the border, guess what? You're going to have a lot of people walking across the border. And that's what we have now. So the same thing is true with regard to rent. If the government is sanctioning non-payment of rent and telling you, hey, you know what, you can pay in a couple of years, then why would you do it? So let's talk about the county. The county deals with not one, not two, but 3 phases. But once again, I'm reminding you, it affects every city in the County of Los Angeles, and of course unincorporated areas of the County of Los Angeles, except unless that city has an eviction moratorium that's more strict, and that would be Beverly Hills and Los Angeles. So let's go over the 3 phases that the county came up with, just to confuse everybody. So phase 1, that deals with a period of time from February 1st, 2022, that's right now, through May 31st, 2022. All no-fault evictions are prohibited from that time, even if your property is not under any rent control. So once again, like in the city of Los Angeles, an intent to demolish the property. That's why I bought it. I wanted to put up 6 condos. You cannot do that. If you want to sell your single-family home, it's not subject to any rent control. I need to get the tenant out. Can't do it. Under the state law, you're allowed to do that substantial renovation. That would be considered a no-fault eviction. You are prohibited from doing so. And if you're in the county of Los Angeles, not the city of LA or Beverly Hills, and you're not subject to any rent control whatsoever, the tenant is on a month-to-month tenancy, normally you'd be able to serve either a 30 or a 60-day notice. That's considered a no-fault eviction, and you cannot issue that notice. Once again, we're talking about phase 1, February 1st, 2022 through May 31st, 2022. Permissible reasons for eviction during phase 1. Can you? Yes. You can do so on the basis of unauthorized persons or pets, unless it's COVID related. You have to come up with a good one. As how it's COVID related that I needed to bring in a Great Dane. But assuming they can't, then we can proceed forward with an eviction. Any violation of the rental agreement, such as alterations or parking. You can evict for nuisance. Obviously, the guy is playing loud music into the late evening, early morning hours. And refuses to quiet down, or is being threatening to other tenants, threats, or maybe even acts of violence. You can also evict, which is not true in the city of Los Angeles, but you can also evict if it's an illegal unit. In that situation, you would have to pay relocation, which is 1 month's rent if you're not subject to any rent control. But you do have the right to evict for an illegal unit. Also, you can evict for failure to provide access. Again, we're in the county. We're in phase 1, February 1 through May 31st of 2022. You can evict for failure of the tenant to allow access, but the access must substantially endanger the health of the tenants or other persons. And of course, if you do go into the unit, you do have to use proper COVID-19 measures have to be taken. So basically, you're somewhat limited if you just want to do an inspection or something to that effect, and the tenant fails to provide access. That would have nothing to do with the concept that it would substantially endanger the health of the tenant or others. So you would not be able to bring forth an eviction. But if it does, then certainly you can for failure to provide access. During phase 1, once again, February 1st through May 31st, we can proceed forward on rent owed based on our standard 2-page 3-day notice, which the association has. But that's from the period of, and I'm sorry to make this so confusing, but quite frankly, I didn't write this law. For the rent owed from October 1st, 2021 through March 31st, 2022, so that's right now, that period, you would serve the standard 2-page 3-day notice, the new one that just came out. You have to apply once again, so it's just basically like the state. You have to apply for the rent relief, After the application is gone for 20 days, you then can proceed forward with an unlawful detainer action. You won't be able to take a default unless you get a rejection or unless you have some way of declaring that the tenant did not comply with the rent relief action. So basically what the state has, the county of LA has in their phase 2, but only for the period of rent owed from October 1st, 2021 through March 31st, 2022. Jeff, are you getting this?
That's tough.
You're not getting it? You're not writing this down?
Writing it down.
Okay, good. Okay, well, you can always call the office and we'll go over it again. However, what happens from rent that's owed from April 1st, 2021 through May 31st, 2022? Actually, I meant to say from April 1st, 2022 to May 31st. So for that 2-month period, we're still in phase 1. Can you bring forth an unlawful detainer for that 2-month period? So that's coming up. April's coming up not too long. In that situation, you would serve a standard 3-day notice, not the new one with the 2 pages. You would serve a standard 3-day notice. The old ones, you can dust them off and bring them back. And you're allowed to proceed forward with that unless the tenant, within 7 days of the due date, has communicated to you that he is impacted by COVID. If notice is provided within 7 days of the due date, so let's pretend we are at April 8th, 2022, coming up in about a month and a half. You haven't heard from the tenant. We can now serve, even though we're in the county, again, exclude Los Angeles City or Beverly Hills, we can serve a standard old 3-day notice and proceed forward with an eviction. We don't have to comply with the rent relief program because that's over as of March 31st. And we can proceed forward with an eviction. If the tenant has given you notice for that 2-month period, April through May of 2022, then he doesn't owe you the rent until May 31st, 2023, 1 year later. So, in most situations, and this is what you have to think about, my property's not in LA City and it's not in Beverly Hills, but I am in LA County. So I'm going to wait to the 8th of April. And unless I got notice from my tenant, I'm going to serve one of my old 3-day notice forms. I'm going to wait 3 days. Then I'm going to call Dennis Block and we're going to start an eviction on the basis that the tenant did not, within 7 days of the due date, notify the landlord that he's still affected by COVID. Really, who's still affected by COVID? Okay? And we can proceed forward with an eviction. Now, I've got some good news for all. Good news? Is that possible? Yes. For all commercial landlords in the county of Los Angeles, again, excluding City of Los Angeles and Beverly Hills, excluding those, you can serve a standard 3-day notice, the old 3-day notice form, on any commercial tenant who owed you rent from February 1st forward in time. How many out there right now have a commercial tenant who owes rent as of February, right now? Go get a 3-day notice or call our office, and we can start an eviction right now, today, on any commercial tenant, right now, for the February's rent or any time thereafter. All protections are over. There's a debate in my office whether you can terminate a month-to-month commercial tenant right now by serving a 30-day notice. And there is a debate in my office, and my position is that we can. So we'll talk to you about that if you just want to serve a 30-day notice. Hey, I just want the tenant gone. It's a commercial tenant. He's on a month-to-month. Can I serve a 30-day notice? Again, if you're not in the city of LA or Beverly Hills, we can just serve a 30-day notice and they have to vacate the unit. If they owe you rent, I'm not talking back rent, I'm just talking rent from February forward in time. Let's serve a 3-day notice and we can commence an eviction. Nothing prevents us. Now, for you commercial landlords where rent was owed from March of 2020 through January of 2022, I think that's about 17 months. If you have 9 employees, if the tenant has 9 employees or less, that money is not considered rent anymore. You can't sue for it, but the tenant is required to pay as of January 31st, 2023. January, look at these dates, guys. January 31st, 2023, which means on February 1st, 2023, oh my God, that's a year from today, I can then file a civil lawsuit against that tenant, a civil lawsuit, not an eviction. If that tenant has 10 or more employees, 10 to 100, then the tenant only has, I kid you not, till July 31st, 2022. July 31st. That's like about, 5 months from today, if they've got 10 to 100. Most people of their tenants don't, so you're going to have to wait till basically through January 31st, 2023 to pay. Okay? Is that if you do have a commercial tenant and he owes you rent for the month of February, my position is we can serve a 3-day notice now or a 30-day notice to get the hell off our property. Okay? Okay, we're still in phase 1. Remember phase 1, February 1st through May 31st. Okay? Can you move into your own property? Again, if you're in the county of LA, excluding, I keep saying it because I know I'll get questions on it, excluding the city of Los Angeles and Beverly Hills. And the answer is, can you or a qualified family member? Well, what's a qualified family member? Your sister? No. Your brother? No. But it's grandparents, yourself or your spouse, your children, or your grandchildren. That's considered qualified family members, or yourself. If your property was purchased prior, these dates are crazy, prior to June 30th, 2021, then you have the right to have a family member, a qualifying family member, or yourself move into that unit. You have to occupy the unit for 36 months. Once again, this is for property that is that's not subject to any rent control whatsoever. It's a single family home in the city of Bell, or property that is subject to them. You have to, you can only do it, move into your own unit, if the property was purchased prior to June 30th, 2021. I'm not sure on what thought process the supervisors for the county of LA came up with that date, but that's what the date is. The person who's moving in must be there consecutively for 36 months. Here's another kicker, that in phase 1, that the tenant must be current on his rent and not COVID impacted. So I guess they don't want you to say, you know what, I'd rather have my son move into this unit because the guy's not paying me the rent. So you can only pick units where the tenant is current in the rent and is not impacted by COVID. It's kind of insidious. It must be a similarly situated displaced tenant. Let's try that again. Similarly situated displaced tenant. What the hell does that mean? Well, that means if you're going to evict somebody who's 62 years of age or older, or is handicapped, or has minor children, then you have to have a like person move in. So the fact that you want your parents to move in, but they're not 62, but the tenant is 62, then during this phase 1 period, you cannot have them move into your own unit. You do have to pay relocation money. Relocation money is based on a formula that the that the county has come up with. I'll give you an example of one, that if it's a one-bedroom and there either has children or senior citizens living in that and you want to have them move, that one-bedroom, you'd have to pay relocation money in the sum of $10,675. Okay, so that's phase one. Now, the only crack that I've found in phase one in terms of doing an eviction would be once April's rents come and the tenant within 7 days hasn't notified you that he has an inability to pay because of COVID, we can serve a standard old 3-day, one-page notice to pay rent or quit, and then proceed forward with an eviction. So that's the trick on phase one. And also we know that commercial evictions are opened right now. We can go forward on any rent owed from February 1st. There is no protection under the county law. Once again, we're not talking about the city of Los Angeles. We're not talking about the city of Beverly Hills. We're talking about every other location inside the county of Los Angeles. Let's move on to phase two. I think I lost about half of you out there, but I'm trying, believe me, ladies and gentlemen. You should have seen how long it took me to figure this out, so I can understand your dilemma in hearing me, but I'm trying to go slow on it. Phase two for the county. That's a period from June 1st, 2022 through December, the end of this year, 31st, 22. You can proceed forward on a case for failure to provide access. It doesn't have to substantially relate to health or safety. If a tenant refuses access, that would be a ground for eviction. From June 1st forward in time, you can proceed forward even if you had no notification that the tenant has an inability to pay within the 7 days. You can just proceed forward on any non-payment of rent case with the old standard 3-day notice for rent owed, and that would be from the period starting June 1st, 2022 through the end of phase two, which is December 31st, 2022. There's one exception. There has to be an exception, right? If your tenant income is at or below 80% of the area median income as established by the Housing and Urban Development and has given you notice to the landlord within 7 days, then that person would be exempt. It would become a civil debt and you wouldn't be able to collect for 12 months, and it's just a civil debt. You can't do that as an eviction. So this would be where the tenant self-certifies his income level and his financial hardship and gives the landlord notice. But again, that he is either at 80% or less for the area median income as established by HUD. But unless that tenant is of that exception, all other tenants, we can proceed with a standard 3-day notice in phase two. We don't have to get any notice from the tenant. So if the tenant, for example, tells you, hey, I can't pay because of COVID, that doesn't meet the criteria because he'd have to be earning 80% or below for the area median income. Okay? So in those cases, we can proceed forward. Also in phase two, we can proceed forward on an owner or qualified family member move-in. There is no purchase date requirement. I don't know why that was in there in the first place. And it doesn't have to be similarly situated, like if I'm evicting someone 62, I don't have to be 62 to move in. But you do still have to pay relocation, which I'm not sure how they figure that. They do have their formula, but I don't understand why you'd have to pay relocation for a single family residence. But that's what because you're not subject to LA County rent control. But that's during phase two, which once again is from June 1st, 2022 through December 31st, 2022. Owner or qualified. You do still have to pay, once again, that relocation as defined by the city. Also, people have asked me, what about rent increases for properties subject to the county? Those are for unincorporated areas. And there shall be no rent increases during phase 2, once again, from June 2022 through December 2022. No rent increases for properties subject to the LA County unincorporated rent control. By the way, if your property is not subject to rent control at all, you can raise the rent to market level. I don't care what jurisdiction you're in or what the city or anybody else is saying. If your property is subject to statewide rent control, regardless of its location, you can raise the rent. Under statewide rent control right now, the rate is 8.6%. So you can do that rent increase. Even if the tenant's not paying, you might as well raise the rent. It'll just be a bigger obligation on his part. Let's move on, finally and mercifully, I might add, to phase 3. Phase 3 is from January 1st, 2023 through June 30th, 2023. So that's another 6 months going into next year, 2023. In those cases, evictions for non-payment of rent can proceed unless, again, you're part of that 80% or less for the area medium income. All other evictions for residential tenants are lifted. So if I've got a single family residence and I just want you out because God knows I'd like to sell this place, and I'm not subject to any rent control, commencing January 1st, 2023, I can issue finally a standard notice to quit. I don't have to have a reason. Or, for example, if my property is in LA County, not in the city of LA or the city of Beverly Hills, and I want to do a renovation eviction because my property is subject to statewide rent control, then I could serve a 60-day notice on the basis that I want to do a renovation eviction, or if I want to move into the unit, etc. Even if I am subject to statewide rent control where I would have to pay relocation, but the relocation is only 1 month's rent under the statewide rent control. I know this is a lot to chew. This has truly been an abrogation of property rights for income property owners during this pandemic period. Nothing about these laws are constitutional, and I'm sure the city and the county will eventually have to pay a big bill once the proper courts hear and decide on these lawsuits that have been filed. But in the interim, let's see what we can do in terms of enforcing whatever small rights we have. I have gone over some cracks that exist with regard to even the city of Los Angeles, to the county of Los Angeles, and of course under statewide rent control. Guys, if you have any questions and you don't get to them today, please call our office. We do have many attorneys who are waiting to answer your questions, and we're happy to do so as members of the Apartment Owners Association. It's our pleasure to assist the members by calling us, and I'm on the phone, believe it or not, as much as anybody else. So I think right now, young sir, Mr. Jeff, we're going to open it up to some questions. Try to take it easy on the old man.
All right. Well, one thing that I was I'm really confused now because I thought that nuisance and unauthorized pets, occupants, I thought that those were protected in phase 1. And so could you clarify that one?
Yes, the way it's written in phase 1 is that we can evict for unauthorized persons, pets, or obviously nuisance unless it's COVID related. That's in phase one, which again is, and we're talking about the county, not the city of Los Angeles. And that's again from February 1st, 2022 through May 31st, 2022.
Okay, great. And anyway, so yeah, now like there are a lot of questions already, but I'm gonna skip through the ones that have been asked and just start from where we're at, because many of the questions you answered the questions when before people asked the questions, and so yeah, I'll just start now asking questions or looking at the questions. And just before we do that, yeah, let me see. Again, closed captions on Facebook if you didn't catch that, if you came in late. And yeah, so we'll get started here with questions. Guys, was there I'm sorry? Okay, yeah, we do have a message from one of our sponsors here. We're going to hit that real quick, and then we're going to get into questions.
Hello there, AOA members. This is Daniel Sharabi, CEO of Livable. We've been partnered with AOA now for some years to bring our ratio utility billing services to membership. And what really sets us apart, aside from quality service and taking great care of your residents and billing them back fairly and accurately for their fair share of utilities, is that we have no minimums. So that means if you've got a duplex or a single family home with an ADU, we're happy to help facilitate the utility bill back on your behalf. So we would love for you to get in touch and join all of these happy customers in using our service and celebrating conservation, but also increasing your net operating income. Livable.com/AOA is where you can find more information and ways to get in touch with us. Look forward to getting some time scheduled and to telling you more about the program and how you can do your part to promote conservation. All the best and enjoy the
Okay, great. Thank you so much for hanging with us here, and we will get started. And looking at the questions, Angie on YouTube, can a landlord still charge RSO fees?
Good question. You can certainly charge RSO fees.
Great.
You know, I do want to say one thing, Jeff. This is probably one of the most, dealing with 3 different ordinances and trying to mesh them all together for everybody to understand them. But one of the great resources is the AOA website, where you can go to this seminar in days to come. It will be posted on YouTube and from the seminar, and you can replay this and write it down. So any part that you were confused about, you can re-listen to it. So this is a live event right now, but that this seminar will be posted, and you guys will be able to follow it from days to come.
Right, and those phases are also outlined. I think the city put something together outlining that, and then with the email that we sent out for this event, there is an article, and we'll have a link of the article. It's basically just what the city wrote up on it, and it gives a summary of the timeline. And so for some of you, I know some of you are asking for a visual, and yeah, visual would be great. I think we all have different learning styles, and we're lacking a visual for you at the moment. But yeah, it is very confusing for everyone, and I think they make it confusing on purpose. They're trying to trip you up. They're trying to make you walk gently through everything, and again, it's taking property rights, and we are talking to lawyers about lawsuits. There's a lot of things that are in the works. If you have been harmed by this, you definitely write AOA, and we'll just have a list. If you're willing to be a plaintiff, then go ahead and we'll put a list together of people, and we'll take a look at that. And in today's economy, the way that they look at all that, if you're the little old lady from Pasadena, they're going to look more favorably on that. If you're the someone like that, they're going to look more favorably than if you're the guy that has 500 units and one person's not paying you. So if you have a good case, if you have that kind of the kind of person that looks more like a victim than that, we're all victims actually, but we're all also overcomers, right? So we're not going to let this thing beat us. We're never going to give in, never ever, and we're going to do what we can. And with all that said, lawsuits can help, and these people, they're nuts. These people in office are nuts. They want to hear how bad you're hurting, and then that will confirm that they've done the right thing. So the way they are is so weirdly wired that we have to switch it to how this is impacting tenants, which is absurd, but this is the upside down world that we're living in. So all that said, we're going into this. So here we go. Janice is rent control city of LA. Thank you, Janice. And so by the way, if you have to tell us where you're located for us to really be able to give you a good answer. And so definitely say where you're at, because location matters. And sometimes, so here we go. Janice, in rent control city of LA, can a brand new tenant in 2022 stop paying the rent and claim COVID?
And the answer is we're seeing this all the time. It's a true fraudulent situation where a tenant moves in, pays the first month's rent, pays the security, and then in the second month claims COVID. Based on the moronic laws and ordinance for the city of Los Angeles, that tenant can now sit there through February 7th, 2023 and not pay any rent. And he doesn't even have to apply for the rent relief. So this is what many of my clients have already experienced, where people move in. We must be really careful when renting units now. I would definitely recommend that you get a 2-month security plus the first month's rent. Mm-hmm. If you can get advance rent from 6 to 12 months, that's also legal. And it goes without question that you've got to screen these tenants through the Apartment Owners Association, their credit checks, eviction checks, criminal checks are second to none. And you've got to be so careful, because right now in the city of Los Angeles, if a tenant just moves in and doesn't want to pay rent thereafter, there's really little that you can do.
Yeah. And thanks for the stroke on the tenant screening stuff, but we don't mess around with that. We call it the double whammy, because we use, for the eviction, we use 2 different companies, and those companies have overlap, but there's also places where both of those companies miss. And so if you're using any other company, they're using one, they're not using 2. And there's a lot of other good reasons to use it, but I'll just stop there because we have so many questions. Okay, can Dennis clarify the roommate rules under 1482 for non-exempt homes?
Under 1482, if it's a single family home, you're not under any rent control. So the state, under their statewide rent control, really hasn't defined renting out rooms inside a particular structure. So I would think you're safe unless you're, of course, subject to some local jurisdiction like Los Angeles.
Okay, Jenny, do I need to do an eviction, or can I take the tenant to small claims court for the amount owed in rent?
Again, we would have to know where your property is located. So, for example, in Los Angeles City, rent is not going to ultimately be owed for 1 year past February 7, 2023. So that's February 7, 2024. In other areas, for example, in Orange County, you can bring forth small claims court right now. And if it's rent owed anywhere between the period of March 2020 through September 2021, then your property, you're not subject to any limitation with regard to small claims court. You're not subject to the $10,000 limitation. So it really depends on where your property is located.
All right. Vincent, is phase 3 passed? I thought it's only phase 1 and 2 that were approved, and so no, this is a 3-phase program that they all put together. It's passed. This resolution is passed for the county of LA. Darren, how can you prove nuisance?
Well, how you prove nuisance is very simple. I mean, you're going to need to have witnesses come to court to state why the person is creating a nuisance. So, for example, common nuisance situations that we see is where the tenant is just screaming and yelling loud music into the late evening, early morning hours, banging on walls, that type of stuff, and he just refuses to quiet down. Well, that's going to require that I have other tenants in the building come to court. I can't use, in most circumstances, any kind of a written statement by other tenants. I need to have them come to court. Now, in most situations, though, it doesn't come down to an actual trial where I need witnesses. Either the case is settled or the tenant moves or something happens along the way. But there is a percentage of cases where I would have to have witnesses. And of course, we get the situation where the landlord will say, well, gee, the tenants are really bothered, but they're afraid for retaliation to come to court. And in that situation, if I don't get cooperation from other tenants, then I'm not really going to be able to prove my case. But to answer the question, yes, you need to have live witnesses to state exactly what the tenants have done. Now, we have a case, for example, I don't need any witnesses, and it is a nuisance where we have this tenant who's stealing Amazon packages, and they're doing it right in front of a video camera.
Yeah.
So that's a case that we're bringing forth right now. And we have the tenant dead to right as stealing other person's packages. So I don't really need to have a witness, so it certainly is nice to have the person whose package it was, come to court. But again, we have photographic proof of what the tenant has done.
Yeah, and last week we literally had a guy talk about how to reduce crime. The dude did 12 years in a maximum security prison, and then he came out and did 10 years of property management. And he had really good ideas, but one of them is that you got to put cameras up and you need to have everything well lit. And that would be another benefit there. You might catch some things there if the cameras are in the appropriate legal locations, of course, with that disclaimer. Okay, we purchased a 4-unit with our VA home loan and with the intent to move in last month. Are we not able to evict? We're in the county of Los Angeles. This is Eric.
Okay, well, again, in phase 1, you can, but you have to, number one, pay their relocation money, right? It has to be a property purchase prior to June 30th, 2021, and it has to be a similarly situated displaced tenant. So in other words, it's 62 or older, children or handicapped. If they're not, then anybody can move in. But again, that tenant also has to be current on his rent and not impacted by COVID. So that's what you can do right now through May 31st, 2022. But if you merely wait until phase 2, which is June 1st, 2022, then you can move into that unit. There's no purchase requirement, but you still have to pay the relocation. So just hang in there. I get clients who say, look, I purchased this where it has to be owner occupied. I mean, that's the terms of the loan that I got. But again, the politicians and their laws have nothing to do with you and your bank and your loan. So it makes no difference that's a requirement of your loan. The politicians don't care about that.
And that relocation fee, you said it was 10,600 and something?
Well, that would be, and I actually have a formula here. If it was a 1-bedroom and it was like for a senior or people with minors, it's 10,675 to go. If it was for example, same scenario, but it's a 3-bedroom, then it would be 16,000. So they have a matrix that you can get, LA County Rental Assistance FAQs, and see, I have it here, if you can see that. And it has a matrix of what kind of a unit and who's in the unit, and that's the relocation that has to be paid.
Great. So we'll try to get that up in this video at the bottom. I think that.
Again, we're not talking the city of Los Angeles. We're not talking the city of Beverly Hills. We're talking every other place in the county of Los Angeles.
Right. Commercial tenant in LA City doesn't want to leave. We've been asking for the space for over a year, closer to 2 years. Can we evict?
And the answer is no. You're in the city of Los Angeles. They have pandemic eviction protection for residential and commercial tenants, and it's continuing until February 7th, 2023.
All right.
Crazy.
Lee Sally in Los Angeles, regarding eviction not allowed if tenant's income is under 80% of the area median income. Is this something the tenant declares? Do they need to prove it? Is it our responsibility to verify in advance, or which ways are we to go about it?
Did you say in the city of Los Angeles?
In Los Angeles. So
okay, city of Los Angeles, you don't need anything. You just say COVID and you're done. The magic words, say COVID. But if you're in the county, it's called, the way the law is written, it's self-certify.
Right.
Self-certify. You know what, ladies and gentlemen, I make only 70%, of the annual median income. And if I say it, then you have to accept it. It's insanity. There's no proof required. But remember that you have to communicate this to the landlord, okay? This is in phase 2, within 7 days. So, actually, it's also in phase 1. You have to communicate that within 7 days. And if you don't, then we have the right to bring forth an eviction.
Mm-hmm. So that's the one little crack.
Yeah.
The one little crack. And that whole self-certify thing, that's something that that's a big deal, and that denies due process for housing providers. So that is a great lawsuit that is going to happen soon. Okay, what legal challenges are pending? So there's this, what I just talked about is something that we are pursuing. And is there any what other legal challenges do you know of, Dennis, that are noteworthy?
I basically know of 2, and I know our association is going to be spearheading a campaign as well. But again, sit back and let's see where the dust settles. Unfortunately, these lawsuits take a while to prosecute.
Right. Okay, what should landlords in LA City do if their tenants refuse to cooperate with ERAP?
This is the biggest assault on income property owners. As I stated at the topic, at the beginning of the topic, was that in the city of Los Angeles, you can literally be without rent for 35 months, going from March of 2020 through January of 2023, 35 months. And of course, yes, you have by the way, that's also true for commercial. But if you're residential, at least you have the right to apply for the California Rent Relief Program under housingiskey.com. But if your tenant doesn't apply, what can you do? Well, all you can do is send them a letter saying, hey, I don't know what the problem is, because you're ultimately going to owe this money, really, in January of 2024. Insanity. Actually, February 7, 2024, you'll owe the money. So, but I would encourage the tenant, say, look, at least your obligation is going to be taken care of if you merely comply with the application process. But in a lot of cases, the tenants don't want to comply because they'd be committing perjury. Because, in fact, they haven't been impacted by COVID. And again, who has really been impacted by COVID? These politicians are sitting there and saying, oh, there's a new wave of a new variant that's come. Who's really affected? Who's really missing work? Who's really not being able to pay their bills? All this is a theft, a legal theft against property owners. And what about commercial landlords in the city of Los Angeles? They're still under a 35-month restriction on getting paid. They don't even get the rent relief. You can't ask for the California rent relief because it doesn't apply to commercial. So if you were smart and said, hey, you know what, I don't want to deal with residential tenants. My business formula is I just want to have commercial tenants, less to deal with. I don't have to worry about kids screaming or dogs barking or, improper noise coming out from the unit. I just want commercial. Well, look at you now. You're sitting there on that business plan 35 months, literally without any payment. I mean, that's another lawsuit ready to happen. And there's no basis that you're going to get any money. And yet your property taxes are due like anybody else. And you've got to pay the utilities for the building, et cetera.
All right, this is Eden. A tenant denied access to a bedroom repeatedly when a pest control team was at the unit. Is this a strong case to consider eviction for in the city of LA?
In the city of LA, you could probably do that. I'm not a big fan of access cases in general. But if the situation is such where because of the failure to allow treatment, we're now having a problem in the building, I think it would rise to a level where that failure to provide access does constitute an evictable offense.
All right, Felicia on YouTube. Do these ordinances apply to tenants who rent rooms?
Yes, they absolutely do. So in the city of Los Angeles, you'd be hard-pressed to evict a tenant. You're living in the unit, the tenant, and you just don't get along. The tenant is considered a lodger since you're in the same unit, and he's just getting a bedroom. You still can't ask that person to move. There's no-fault evictions. And you can't evict based on non-payment of rent.
All right, Natali. My property is located in Los Angeles, 90022. Which part of unincorporated area of Los Angeles County? Which is part of unincorporated area of Los Angeles County. My confusion is, do you go based on Los Angeles ordinance or go by Los Angeles County ordinance?
It would certainly, 922 is East LA, and that would, if it's multiple units, actually even if it's a single family home, you're under LA County rent control, and you're under the LA County eviction moratorium ordinance, not city.
All right. Shannon, does the non-payment of rent include those on Section 8? Because Section 8 normally adjusts tenants' rent if their income changes.
Well, again, any rent increases have to be approved by Section 8. If they give a rent increase, they give a rent increase. The issue would be whether if they told the tenant to pay more money, would the tenant be obligated to pay it? I think so in that situation.
Yeah, so it's for non-payment, not an increase.
What city?
Doesn't say, but I'm assuming it's going to be, let's call it LA City.
If it's LA City, that's going to be under rent control if it's an apartment, so you never could, even pre-pandemic, you can't ask the tenant to leave. If you're not subject to any rent control and you're not in the county of Los Angeles, because again, right now there's a no-fault provision, but if you're not in the county, you could serve a notice based on economic reasons, which would be a 90-day notice on Section 8 tenants.
Okay. All right, Mary. I increased the rent by 4% on January 1st, and January 15th on single home in Pasadena and Altadena, respectively. Was I allowed to do this?
Yes, you were allowed to raise the rent 4%, and you can continue to raise the rent till market level right now. If you do go above 10% in combined in any 1 year period, you need to serve a 90-day notice. So if you gave another rental increase for 7%, for example, you'd have to do a 90-day notice if it was in the same year that you did the 4%. But you certainly can raise the rent to market level.
So that's
for
LA.
a non-rent controlled, regardless of where the property is located.
Right.
So if you're in the county of LA, but it's a single family home, you can raise the rent, or a condo or a townhouse.
Great. All right. Single family house in the city of Santa Clarita. Can I able to evict tenant after January 23 without paying any relocation fees? Please clarify. I think January 2023 is what
Well, that if you're in phase 3,
Santa
which is
Clarita.
starting January 2023, the answer is yes. There's no eviction protection for residential tenants. It's all lifted as of January 1st, 2023.
All right. Sam, can I evict on a long-standing violation in LA City? Several years ago, a tenant still living in the single-family residence built an illegal room onto the house. Can I now evict for that alteration?
I think so. I mean, even though one could claim the issue of waiver, but you can't waive something that is against the law. And obviously that room was built without permit. So I would serve a 3-day notice to perform or quit right now, today. And even though you're in the city of LA, and giving him 3 days to put it back. And when he doesn't, then you have the right to evict.
All right. Craig in Northridge. I own a single-family house that I rent to lodgers, and I live there. I have a lodger that I gave a 60-day notice to end his lease. I fear that he might try and stay after the lease.
Did we say city of Los Angeles?
Yeah, he's in Northridge.
Yes. So Northridge, by the way, ladies and gentlemen, is city of Los Angeles, Encino, Van Nuys, Woodland Hills. This is really just areas of Los Angeles. City like Burbank, Glendale, those are separate cities, but all those other communities are just part of Los Angeles. And once again, in the city of Los Angeles, there is a no-fault provision in effect, which means that unless the tenant is doing something wrong in accordance with the LA ordinance, you can't just ask a tenant in a single-family home to move. At least until February of 2023.
Yeah. I mean, it defies what you think. You think we're living in America, but LA County doesn't seem to be like it.
I think they abdicated a part of the United States, right? Started their own government, their own way of looking at things.
Right. Like you would think a whole country would go socialist, but it's like we have a little pocket of a different governance here in the county. Okay. We will still honor an 11. Okay. Can we still honor an 11-month lease to vacate unit? In the county of Los Angeles during this first phase, the answer is no. You can't do that. Even though the lease expired, you can't just ask a tenant to move. If you're in the city of Los Angeles, you're stuck until January of 2023. And is North Hollywood the city of LA or county of LA? So city. And the answer is it's North Hollywood is part of the city of LA. Just like I'll go over some of the list here. North Hollywood, Studio City, Sherman Oaks, Encino. These are all just areas of Los Angeles. Arleta, San Pedro, city of Los Angeles. Winnetka, you name the city. These are just areas of Los Angeles. Right. Do you need a judgment in order for the collection agency to take your case? In our particular firm, we do collections, but only on the basis that there is actual judgment entered. Yeah, and it's clean that way. If you have a judgment, everything moves forward. But if you don't, then
Well, you're going to have to file a lawsuit. I mean,
Yeah.
you can't. I mean, you can. There is a certain amount of collection agencies that will send letters to people who owe money and demand payment, and maybe make a respectful phone call and not violate any Fair Debt Collection Practice Act. But in the most part, I don't usually find that to be worthwhile. If the person owes money, then the receiving end of that is, if they were going to get money, they wouldn't have contacted an attorney. Once they contact an attorney, they realize that the debt's not going to get paid. In that situation, we need to have a judgment. We can file civil lawsuits, or you can go to small claims court, which is generally what's recommended.
All right, Graham Matthews, how do we join the class action lawsuit? I don't know that there is a class action lawsuit.
Yeah, I'm not aware of one, but
Yeah.
if one crops up, trust me, you'll be notified
Right.
by the attorneys that are filing these, because they want as many members as possible.
Yeah, we'll put something out there for sure, and man, it would be great. But if anyone has, yeah, okay. So Felicia, my property is located in LA County, but individual rooms are rented out on a month-to-month basis. Do these ordinances apply? And the answer is yes, as you've already said a couple times, John. So if you can not evict, better to keep the unit empty. What do you think?
I get that question all the time, and I can guarantee you 100% that if you don't rent out the unit, you will make no income.
That's right.
It's 100%. So I don't think that's smart. But I do think that you can take pretty extensive methods to make sure that you're getting a qualified applicant who will rent your unit, that you have checked them out. Check them out on social media too. Go to the Facebooks and the Instagrams and see if you can find them. It's another way to check out the tenant, in addition to running through the association, of course, the credit check, eviction check, criminal background check, and make sure that you really check out his sources, make sure that he is really working where he says he's going to work. If somebody's working, for example, from the post office or from LA Unified School District, trust me, they're not quitting their job. So that's going to be a pretty good candidate for you to allow to move into your unit.
And, one other thing, like if someone lies or fraudulently does something with their documents in the rental application in that process, and let's say you discover that 5 years later, can you evict for that?
You can. The most rental agreements, I know the AOA, which has an excellent rental agreement, states that that's a material breach if you make any misrepresentations on your application. So in that situation, if the tenant did lie, he was evicted before, which usually is what they make the misrepresentations about, that would be grounds for eviction. But then again, if you have a tenant who's done nothing wrong for 5 years, you're not going to bring forth an eviction at that point in time. But it's only tenants who are usually creating a problem for you.
Right.
Then you can do a little bit of research to see if you have another way to evict.
Right. And yeah, because right now they're saying that 1 in 8 rental applications is fraudulent, which is an incredibly high number, where they're either taking the bank statement and altering it, or they're creating the pay stub online where you pay $8.95 and you can create your own pay stub. So that kind of fraudulent activity would be grounds for eviction.
Yes, in fact, I'm going to put on my application that I'm only 45 the next time I fill one out. We'll see if that flies.
All right. So can you explain phase 2? It looks like we can evict if it's in county of LA.
Okay, for phase 2, you can evict for failure to provide access. It doesn't have to be a substantial health and safety issue. You can evict for non-payment of rent. The only exception would be if the tenant is below 80% or below the area median income. and is affected by COVID and is given notice to the landlord within 7 days of that he is self-certified that his income level is 80% or below, and also that he suffered a financial hardship and has an inability to pay. Other than that, you got a standard tenant who's not paying the rent come June 1st, 2022, and we're not in the city of Los Angeles or Beverly Hills, we can go forward with those evictions.
All right, Armando, what are the costs to evict, both with and without trial? I want to sell my only house I am renting and do not need the stress.
Our fees vary depending on what type of eviction we're doing, be it a nuisance eviction or a non-payment of rent. So that's, but I can tell you our fees are probably 50% of what most of the people charge in our industry. And again, I've been around long enough that we've been able to streamline the way we do our business with our IT systems. So if you are curious as to what our fees are, just give the office a call.
All right, Dave in Redondo Beach, can I raise the rents now? If not, when?
Well, it all depends, Dave. You have to tell me whether your property is subject to any rent control. If it's not, then like a single family home, a townhouse, or a condominium.
Oh, triplex in Redondo.
Oh, it's a triplex?
Yeah.
Okay, assuming that triplex was built more than 15 years ago, then you're subject to statewide rent control. You can raise the rent right now today with a 30-day notice to take effect as of April 1st, and that would be an 8.6% rent increase. If you are lucky enough to own a triplex that was built within the last 15 years, then you're not subject to any rent control, and notwithstanding any politician's disgusting ordinance, you have the right to raise all of those units to market value.
Great. All right, Diane, how do we know if an unauthorized occupant is there for non-COVID related issues and evict?
I can't imagine on what basis that would come into play. I mean, I've come up with a scenario where your kids are home because school is closed due to COVID, and you have to go out and work, so you have to have somebody else come in to watch the kids. That would be kind of COVID related, why you'd have to have another person occupy the premises. But unless you can come up with a scenario like that, I don't see much issue that the extra persons were due to COVID.
All right, Felicia. Tenant in LA County applied through Housing is Key for January and recently notified they got a new job. Are they still protected while waiting for Housing is Key to go through?
This is in what city, please?
LA County.
Well, right now in LA County, you can serve right now today, you can serve a 3-day notice, the new form, but you still have to apply, and the tenant has to apply, and we can proceed forward with the eviction. If you do get paid, by the way, through Housing is Key, or even if the tenant somehow magically gets the money, then in most cases you're going to have to dismiss that lawsuit. But at least you got your rent.
All right, Marco, can you pursue guarantors for non-payment of rent in the city of LA?
Good question.
Yeah.
I'll rate them now. And the answer is yes, if the tenant defaults on the payment of rent, the way the contracts are written for guarantors, then the guarantor would be civilly liable. But the question is, did the tenant default on the payment of rent? Well, he didn't pay for the last 10 months. That sounds like he defaulted. But it sounds like it, but he really didn't default. Because you see, in the city of Los Angeles, the rent isn't due until, if it's COVID related, until February 7th of 2024. So you can't say to the guarantor, hey, you're the tenant of this property with which you guaranteed the rent has defaulted. Well, he hasn't defaulted because your mayor and your city council has extended his time to pay until February 7, 2024. So on that basis, yes, you can sue the guarantor. You just got to wait. Hopefully he's still alive.
Do you put together buyout guarantees, buyout agreements?
Yes, we do voluntary vacate agreements. Ours is truly unique because, for example, in the city of Los Angeles, you can't evict on a straight buyout agreement. It's not a ground to evict if your property is under LA rent control. Our agreements, our voluntary vacate agreements, give us, right now, today, even with this moratorium, the right to evict based on the way we structure our agreement.
All right. So there is a difference.
Right. And I want to add that if you do a buyout, people say, well, how much do I have to pay? And I always come back and I go, it's either between $1 and 10 million, somewhere in between. The tenant can agree that he'll move out in 30 days for a ticket to Disneyland. But again, it's whatever you agree. If he wants 100,000 and you don't want to give him 100,000, then there's no agreement. So in that situation, understand that an agreement can be any amount. It's just got to have unanimity. Both sides have to agree.
Okay, here's Marisol, a non-RSO LA city. Can I raise the rent to market value?
Non-RSO LA City, the answer is yes, you can. It's not under LA rent control. You might not be able to evict for non-payment of rent, but you can raise the rent to market value. Again, if you're going above 10%, it's a 90-day notice, but you certainly can do that. What it means if the tenant isn't paying rent is that he'll owe more money on the back end.
All right, Kimberly Price. Can I increase rent in Ladera Heights, 90056, unincorporated LA County, a single-family home/condo?
The answer is yes. You can raise it to market level even though you're under the auspices of the county and their rent control statute. Even though you're exempt from rent control, you're not exempt from good cause to evict. But you certainly can raise the rent to market value.
All right, now back to the very top now. Massis on YouTube. Can we evict tenants for purpose of remodeling the unit in the city of Burbank? Do we have to give them a month free rent, 30 days?
And the answer to that is no at this time. The county of LA has specifically taken in every city except for LA and Beverly Hills. And in at least their phase one, you cannot evict for a eviction. In phase two, you still can't evict for renovation, so you'd have to wait until phase three, which would be January 1st, 2023, and then you'll be able to evict for a renovation.
All right, here's Kendall on Facebook. What is the end game for housing providers? Just wait until the county decides to give back our properties?
I think the end game really is bankruptcy.
Yeah.
Because that's basically what our politicians are forcing us to do.
Right.
I mean, I have told you about some of the bare things that you can do to evict your tenants and get somebody who's willing to pay you the rent and not play the COVID card. But otherwise, you're in a situation where you're just sitting and waiting for either the rent relief, which might never come, or you're waiting for the statute to end.
Which might never come. And that's
well,
why
COVID's going to be here for how long, Jeff?
Yeah. Yeah. What do the experts say? Another couple of years?
Yep.
So our 4-unit apartment.
And by the way, Jeff, how did COVID start?
Let's not get into it.
Okay, just
I
curious.
think it's generally accepted where it started. So it's public information, right? Our 4-unit apartment is in unincorporated LA County area. We sent out an 8% rent increase notice on December 20th, 2021 to start new rent from February 1st, 2022. Is that still effective or no rent increase at all?
if it's subject to the county rent control, you can't do a rent increase. If it wasn't, did they say it was just subject to statewide rent control?
Yeah, they're unincorporated LA County area.
Okay, if it's an apartment, then you're under LA County rent control, and they have stated no rent increases.
Yeah, so 4 units apartment is what they have there.
Yeah, no rent increases.
Well, they just saved them a lawsuit, huh?
Yeah.
Sorry. All right. Could a notice be given to a tenant to move for owner to move in the city of Beverly Hills?
Good question. I'd actually have to look that one up since there's so many different municipalities, but I do believe that Beverly Hills is allowing an owner move in at this time.
Okay. Hey, how about that? Sevi, is an unincorporated city subject to the Los Angeles eviction moratorium if our city has its own eviction moratorium? You've covered that. It's only LA City and Beverly Hills that have one that...
Yes, that are more strict.
Right. Leonard Sharp. Here we go. Can we still bill the tenants for the LA City Housing Code enforcement amount?
You can. Again, if the tenant owes the money. There's no argument about that. You're not allowed to do a rent increase, but you can go for the registration fees, the monthly registration fees, and for the SCEP fees. But if the tenant doesn't pay you, can you go forward with an eviction? And the answer is no, because he's just going to claim COVID. But he owes it to you.
Yeah. Okay, here's Amy. Are rent increases allowed if you have applied for housing is key rent relief?
Applying for a housing is key rent relief is not part of the equation. You can raise the rent depending on whether your property is or is not subject to statewide rent control, or is or is not subject to a local rent control ordinance.
So it's basically whether people owe you money or not, you can raise the rent.
Yes.
Okay, Anna. My client applied for rent relief, but since the tenant declined to apply, they were not able to help her. Anything else she can do?
Really nothing. I don't know what area you're in. Obviously, if you can bring forth an eviction, if the municipality allows you to, I would do that immediately.
Yeah. All right, Fred, what if it's a trust sell buy and the owner is the one that occupied the house? Can we evict?
If I'm understanding the question, the seller of the house has put it up for sale, sold it, and now refuses to move. That's an eviction we can do right now today. We also can do evictions for what they call foreclosure evictions, where the property owner lost a house in a foreclosure sale. That's a case that we can do right now today. So either a sale eviction or a foreclosure eviction. And we can also do an eviction, though we have an appeal going with one particular judge downtown Los Angeles, where the person is what we call a tenant at will, where the person doesn't pay rent. That person is not a tenant, since they don't pay rent, is not afforded any protection under the law. We had an adverse case, one of many that we filed, but one adverse decision by one judge who claims that that person is entitled to protection under the eviction moratorium ordinance for the city of Los Angeles. That judge is wrong, and that judge will see my appeal on her desk shortly.
Okay. Okay, what laws do properties in unincorporated area of Los Angeles County follow? And so, I mean, you've hit this over and over again.
I think I went through it with LA County. It's phase 1, 2, and 3.
Yeah, so
Phase 2, we have a lot of leeway to do things. Phase 3, it's somewhat open-ended altogether. So, and once again, phase 2, as I look at my own notes here, is starting as of June 1st But don't forget, in phase one for the county, unless they notify you within 7 days of the due date, we are off to the races, ladies and gentlemen, which means we can serve a 3-day notice and proceed forward with an eviction. We don't have to worry about applying for rent relief, and we don't have to worry about getting a rejection from the rent relief. We can just start an eviction.
Great. All right. Realty Masters. If an FHA offer is accepted on a tenant-occupied single-family residence in LA County and City of LA, can we vacate?
Single-family home in the city of LA, correct?
Mm-hmm.
And you just want the tenant to move.
Yeah.
Sounds reasonable to me, except the law says you can't. There can be no fault evictions in the city of Los Angeles until, right now, February 7, 2023.
Yeah. All right, let's see. In El Segundo, is El Segundo exempt from rent control?
No city in the state of California is exempt from rent control because there's something called statewide rent control. And that affects every city in the state of California. Now, El Segundo does not have a local rent control jurisdiction, but if you have a property in El Segundo, you have 2 or more units that are older than 15 years, then you're subject to statewide rent control, assuming the tenant has lived there longer than 1 year.
Okay, so for rent increases in cities like Burbank or Pasadena, please cover the rent increases.
Again, if your property is not subject to any rent control, you're not limited, you can go to market value. If your property is subject to statewide rent control, then right now it's 8.6%.
Right, and then how many day notice do you need to give?
8.6% is 10 or less, so therefore it's a 30-day notice. More than 10% is a 90-day notice.
All right, here's Kathleen Yu. We split the lot from a duplex into 2 single-family residences in LA. How are we going to bring eviction to the existing used to be a duplex tenants?
Okay, so if I'm hearing correctly, if you split the lot, now you have 2 lots, okay? And I don't know how you split a duplex, because a duplex, unless you're using loose language, is one structure. So I don't think you took a saw and cut it in half and put one on one lot and put one on the other lot. But assuming it was 2 houses on one lot, you split the lot and you made it 2 separate lots. That's what I think. You've got 2 single-family residences. They're not subject to rent control, so you can raise the rent. But you are subject to LA City and their moratorium against no-fault evictions or evictions based on non-payment of rent until February 7th of 2023.
Okay, my condo's in Tarzana, California. My tenant is over $35,000 behind. I've applied for rental assistance. The tenant has not completed his portion. He refuses. What can I do?
Call me at the office and I'll tell you on a Saturday what I would really want you to do. But notwithstanding, there's really nothing you can do. You're at the mercy of the politicians and city council and mayor of Los Angeles. And again, as I started off the discussion, you could be in a situation where a tenant owes you 35 months worth of rent, and there's little that you can do. You can raise the rent since it's a condo. I would definitely do that so that his bill is getting bigger. Not that he cares, but you might as well. And then once the moratorium is lifted, this tenant, assuming he's still alive and still able to be found, will only owe you this money February 7, 2024. 2024, ladies and gentlemen.
Mm.
Crazy. That's what we should do. The politicians shouldn't get their shouldn't get their salary until 2024. That's what it is. What do you think?
Yeah, that sounds good. And also, we should let somebody move into their place, too.
Oh, of course. And with no way to evict. I like that.
They need it. I mean, they need to experience this.
I think this is a great idea.
Okay. Yeah, I think Sheila Kuehl, I hear she's got 3 empty bedrooms.
I would think so.
And she's probably down Santa Monica or somewhere over there. That'd be a nice place to live.
Oh, yes. So she's a wonderful human being. If only Dobie Gillis had married her. Everybody's looking that one up. I think we'll take a couple of 3 more. What do you think?
Okay, that sounds great. Let me see here.
Otherwise, we could go all day.
I know it.
And the old man will keel over here.
Yeah.
But I do appreciate everybody listening to these webinars. They truly are helpful to our community. And again, you can go back and review it by going to the AOA USA website. And this will be there if you missed something or want to take some notes.
Yeah. So here's Tina. What 3-day form do we need to serve for non-payment of rent for unincorporated area in East Los Angeles?
Well, if it's non-payment of rent, that would be a notice to perform or quit. Those are the standard notices. They haven't changed. And those forms are available on the AOA website.
Great. Okay. And we'll just do a couple more here. I mean, yeah, it's just, they go forever. And thank you, everybody, for being patient and also understanding that we're not going to get to everything. Let me see. Yeah, some of these are the same questions. Okay, Diane, what if the family member cannot stay for 36 months, for example, 12 months into, you know how like you have to, there's that requirement of 36 months, and then let's say they get a new job out of state.
Yeah, or let's pretend they died.
Yeah.
Then are you not in compliance? I don't know. They don't list what the penalties would be. So I don't know. Can the tenant come back and now sue you because he was wrongfully evicted because you didn't say 36 months? I don't know the answer to that. And when they write these statutes, they didn't know the answer to that as well.
Mm-hmm. Okay.
By the way, a very poorly drafted statute by the County of Los Angeles.
Yeah, and on purpose too, because they're not. It's not that they're not smart people. They're intelligent people. They know exactly what they're doing. Anna, do you have a free consultation, Dennis?
Anybody can call our office, and we're happy to answer questions. Quick question at no charge.
Yeah.
We've always done that for the Apartment Owners Association.
Yeah.
And people know that I answer the questions like everybody else. Sometimes they get surprised that I'm actually on the phone answering the questions, but that's what I do. I talk to my clients, and I talk to members of the association.
All right. Here's a good one from Boyle Heights. Yvette, tenant will not allow owner access to the house. The roof is leaking, and the owner would like to fix before it gets worse. What are the owner options?
You can evict. I think that would deal with safety and health because the roof can collapse if it's not properly fixed. So if they refuse to let you in, that would be grounds for an eviction.
Okay, how can a Section 8 person ever be evicted if there are no evictions for low-income folks below 80% of area income?
Good question. You'd have to wait for the moratorium to be over, which right now is extended for the county through June 30th, 2023. And in the city of Los Angeles, it's extended through February 7th, 2023.
All right. Well, everybody, thank you for listening in. You can definitely go to the AOA USA website or go to YouTube and type in AOA USA as one word. And then if you type in Dennis Block, it'll probably come up, or type in it's just there right now. So you can get it and watch it again. And if you have questions, you can call Dennis, and he'll help you out. And if you're a member of AOA, give us a call and we can help you out as well. And just be merciful to Dennis and to AOA, because if everybody calls at once, guess what? There's going to be you're going to have to wait a little while. But we pride ourselves on being able to get to your calls, and you always being able to have a person. But when things like this happen, you have 5,000 housing providers that need to know the answer all at once. And so thank you for understanding that. You can also email questions, and we can have somebody call you, and that also does work. And anyway, thanks again. Remember, last week there was that great video about protecting your property, and the thought that I had is, man, if everybody did what this guy's talking about, we would lower the crime rate in the city of LA, and really any area where these things are applied. And if you watched last week, one thing I said was knowledge is not power, but knowledge applied is power. If you watched last week and you haven't done anything yet, why is that? And you're letting that knowledge go to waste. You wasted an hour. And I know I took steps, and always the best thing to do is, whenever you hear something and you need to take action, give yourself 1 week to get that done. Make that the goal and just get it done. And anyway, we'll leave it that one. Next week we have one on how to do a 1031 exchange into a DST. So that's one where you're like, I'm sick of these headaches, I want to sell. That's something you can do. It may or may not be the right time. If you sell when there's blood in the streets, you're not going to get the best deal. But if you buy when there's blood in the streets, you will. So anyway, for wherever you're at, that's your decision for sure. And anyway, we're looking into ways that we can bring lawsuits, and we'll see you next time. Dennis, any parting words for us? Thanks
Just want to
again,
thank
man.
you for the opportunity to speak to our members. And again, if you guys got any questions, you see my 800 number. I'm happy to help you, and really want to thank the Apartment Owners Association for putting on these webinars. It's really an invaluable learning tool for our industry, which again is under attack. And stay strong, stay vigilant, and let's see if we can make this work.
Yeah. All right.